Hello, guys. Today we have a special guest, John Ross, on the podcast, and he is helping especially those investors and members in the audience who are a little bit further ahead in their development of a passive income portfolio. Because as you're getting into 3, 4, 5, 10, 15 properties, you start wondering how can you protect yourself against lawsuits and what would be the right structure, not only for legal issues, but also if you ever want to consider, building your legacy and turning over your portfolio to, the next generation and so forth. So one of the ways to do this is to establish an estate plan together with what's called a series LLC structure. And John Ross is one of the few people in the country that are really experts and have focused almost exclusively on that aspect and how to do it right. So please pay close attention to this session because we are going to discuss quite a few details on how you can actually get started, what to pay attention to, and especially why this approach is actually really protecting you and your assets for any kind of attacks from the outside. Hello and welcome to another episode of the Ideal Investor Show together with John Ross today. And he is a fellow military man. He was with the Marine Corps. I was in the Air Force. So kindred spirits in that way, serving the country and securing the peace, right, Ross?
That's right. Absolutely. Matter of fact, my daughter is in the Air Force.
Oh, cool. Right. Now she chose the right service then. All right. Very cool. So, all right, John, thanks for being on the show. And maybe you can tell us a little bit. I saw that you went to, and I was initially like, did John go to school in California? Because my daughter actually graduated from San Marcos High School. And I'm like, no way. He grew up in Texas and he went to San Marcos High School. But I guess there's more than one. So tell us a little bit, how did you end up actually being in the role that you're in right now?
Yeah, after I got out of the Marines, I went back to college, used the GI Bill, got me a degree in accounting. And really during that period, I really kind of had the idea that I was going to become a tax attorney. So off to law school at Texas Tech with the idea of really, like I said, kind of being a tax attorney. But during that process, I really learned a lot about the estate and gift tax, business entity structuring. And so once I got out of law school, instead of just doing kind of straight tax law, it was more using that tax knowledge in helping families and small business owners figure out how to structure their businesses, structure their estate planning, maximize their taxes and asset protection and all of those sort of things. And I'd only been out of law school for about a year and a half before I decided I needed to start my own firm. Me and my partner, Lisa Schulmeyer, 2 laptops and a card table, and off we went. And we have since grown to several offices across 2 states, and just off we go, continuing to get more and more.
Yeah, that's very good. Congratulations on that success. And I'm only aware of 2 other organizations, at least in that specific area, that operate in that. You would probably say there are thousands of accountants and CPAs and maybe even more lawyers. But this particular area of taking basically investment assets and structuring them correctly for regular people who don't have large corporations or anything like that, maybe I don't know enough about it, but I am not aware that that is a huge field, but it's a very needed field. So before we go into that in a little more detail, since you said you also know something about gift taxes and it's shocking how close we are to Christmas, what are the rules? How much can somebody who has something to give to basically not have to pay taxes and put it to good use? Let's put it that way.
Well, particularly here at the end of the year when it comes to gift taxes, a couple of things. One, if somebody has not taken their required minimum distribution and they are charitably minded, if they're already giving to charity, assigning their required minimum distribution from their IRA directly to their charity or charities of choice makes a whole lot of sense. So that's one. On a straight gift tax, the inflation numbers for this year, you can the annual exclusion amount is $16,000 per person per year. So you can give $16,000 each to however many people you want out there, and that's no tax on you, no tax on the recipient. And then what a lot of people don't realize is that even if you give somebody more than the 16,000 per person per year, all that does is just reduce your lifetime exclusion. There's no tax on gifts to the giver or the recipient until you cross the total lifetime exclusion, which currently is $12.06 million. So there's a lot of folks that they could give away everything they have on the whole planet and there would be no tax to anybody. So a lot of people they're not familiar with that side of the rule.
Yeah, that's a very, very helpful nugget because I've always done it that way with my wife and I being individual people. So we always ended up being at about 30,000 or so. But I wasn't aware that you basically just taking a little portion of the overall freebie, so to speak. So,
Right.
yeah, all right, that's good. Well, see, it was good to ask that first. Now, let's talk a little bit about Series LLC. And I believe I know some of it and hopefully can ask some credible questions. But maybe if you start just setting the stage a little bit, what's a Series LLC? Why do we do it? And how do you prefer to set it up?
Sure. Well, let me just kind of start with I'm in a relatively rural East Texas and Southwest Arkansas, and we have a lot of people that are heavily involved in real estate, whether that's rental real estate, whether that's farming and ranching, timber operations, various things like that. But just take the average rental real estate, somebody that's getting residential rent properties, and go back 20 years when I started doing this. And they would come in and they would say, well, I'm concerned that if somebody gets injured or something in one of my properties, that I'm going to get sued. And the solution to that generally was going to be a limited liability company. Basically creates a liability box around the property where liabilities related to the property don't get out of the box and liabilities outside, for example, a car wreck where you get personally sued, that liability doesn't get into the box to get to the property. So it creates this kind of wall around it. The problem would be, though, that the person I'm talking to would say, well, I have 7 rent houses. Well, back then, the only real solution, I mean, if we created one LLC and we put all 7 rental properties in one LLC and one of them created a liability, well, that liability is going to attach to everything else that's in the LLC. The only other option was to create 7 different LLCs with 7 different tax ID numbers, which would just be a bookkeeping nightmare for these poor people, not to mention the cost of setup and everything else. That was a problem for quite a while. And then finally, and I believe Wyoming was the first state to come up with this concept of the Series LLC. And about half the states in the United States now have adopted this law. But basically, what, in very simple terms, it's a single LLC, but the statutes allow you to create within that one LLC what they call series. Series 1, Series 2, Series 3. And the law says that the liabilities of any one series do not extend to the assets of the other series. And really, this is a gift to the rental real estate investor because now you can have your just one LLC. But within that one LLC, you can have your property at 200 Main Street as Series 1 and your property at whatever address as Series 2. If Series 1 creates a liability, worst case scenario, you lose the assets within that series, but you're not losing all of the properties.
That's very good. And let me try to give that back the way I typically try to describe it. And you tell me if I got it right. I always first try to make people understand there is your business, ideally, and your private life. And what you want to avoid is that when something goes wrong with the business and you have a house and a car and maybe some collectibles and some art on the wall and stuff like that, if something goes wrong with the business, like you called it a liability, you don't want somebody in a court to say, okay, now you are owing $1 million, and they basically take everything on your private side to pay that $1 million. The other thing that I always say is think about it, and I hope I'm right with that. Think about it like you have a mother and you have children. The mother organizes everything, is sitting kind of like on top, like the queen. But if one of the children screws up, then the queen and all the other children are not necessarily affected by whatever happened there with that one not so nice kid that came out.
That's a perfect example. I like that. I may steal that one.
Yeah, hey, feel free. Yeah, I mean, I'm always trying to be in relatable things because I found a lot of people say, liability, what qualifies as, and I know you could rattle all kinds of legal terms down on what that means, but yeah, so I'm always trying to translate into easy things. Now, one thing that is an issue, or at least I've heard it to be an issue in my own series, we try to navigate around it by putting the existing properties, because I already had a bunch of properties before we established the series. To get around it, we basically put the properties themselves in a land trust and then have the land trust, the individual land trust, be owned by one of the, or each one separate by a series, to avoid the mortgage companies to have the due on, what's it called, due on something,
Yeah, the due on sale clause.
due on sale clause. Yeah. So what's your take or opinion about that?
Yeah. So when, and a lot of these folks, they do have debt on these properties. And if you are transferring the underlying title, then, if you say from you individually to an LLC or something like that, that at least normally it could be something that would trigger the due on sale clause. And what that means is basically the rest of the note comes due in one payment, which, that can be financial disaster.
Yeah, especially, I mean, in my case, and I think this is true for other people that we have encouraged to do a series LLC, the LLC or the series, I should say. But even if you go to the mother company, typically is not equally credit worthy in the sense of getting the same kind of loans or mortgages or stuff like that than an individual like myself or anybody who is investing would be. So it's not just, okay, the bank can call the loan, you have to repay the loan. You could theoretically say, well, then I just get a new one. The property is still the property, but it would never be at the same terms, right? So I interrupted. So keep going on what your thoughts are.
No, but yeah, you're exactly right. I mean, if you bought that property, say a year and a half ago, you might have a note on it that's as low as, 2%. And you dang sure not getting 2% today. And so, yeah, just losing the terms of that could be a big deal. So, yeah, a lot of times using something like a trust where generally speaking, the trust is still going to be treated as you. And in fact, there's a law out there called the Garn-St. Germain Act that came out somewhere around 2008 at the when the mortgage crisis came in, that essentially prohibits a bank from accelerating a mortgage on a transfer to a trust as long as you and the trust are basically still treated as the same individual. It's a
Yeah,
trust that you
exactly. Yeah.
create for your own benefit, right? And so that gives you a way kind of around that where you don't have to worry about, you're still going to get the protections of the LLC without having to worry about triggering that due on sale clause.
Yeah, and I learned in my process the only difference would have been that it's obviously a little more paperwork to set up the individual land trust and then basically have the land trust be owned by the series and everything else going up to the mother. But other than paperwork one time and then it's basically there, that worked out pretty well. It sounds like if somebody is in a situation where you already have properties with leverage on it, that you would probably also recommend the same to keep the good rates intact, right?
Yeah, absolutely. And like I said, unless you've got if you've got a real good relationship with a local banker that, you feel relatively confident that they would just, assign the terms of the deal to the new series, yeah, great. You could try that. But if that's a no-go, or especially if you're using one of the, big banks, you're never going to get in touch with somebody that'll allow you to do that. In which case, yeah, this using the trust, transfer the property to the trust, no issue. Trust goes to the series, and bam, there you go.
Okay, yeah, that's very cool. And I'm grateful that you explained that because, hearing it from an expert is always good for our audience to realize, okay, there is a way, and coming back to where you started, to separate basically my private assets from these. And yes, some people might say, well, but those are my houses. But like you said, the risk of being sued for somebody falling down the stairs and claiming that the stairs were unsafe or something like that is always there. Now, the other thing I wanted to touch on with you is there is also this kind of goal of anonymity, where if you have a property in a land trust that is owned by a series that is managed by a mother LLC, that creates much more anonymity to the actual underlying owners. What's your take on that?
It's kind of funny. I'll use one of my other attorneys that works for me. Several years ago, I hired another attorney, and his name's Ben King, and he came from the plaintiff attorney side of the law field. He big national firm that sued everybody that they could ever think of. Right? That's what he did. Right? We always kind of joke that I brought him over to the other side. I flipped him. But one of the things that he would often note is that those plaintiffs attorneys were very, very busy. And they would have cases in the pipeline. And so if you were injured and you reached out to that plaintiff's attorney, they may sign you up, but the first thing they're going to do when they sign you up is they're going to put in their computer system the end date on the statute of limitations. What is the last day that they can file suit? And often that's maybe 2 years from now, right? Or 2 years from the date of the injury. And that gives them time. Now they can go back to work on the cases that they already have in the pipeline, and then they just have a little trigger a little further down the line. So here they go. Maybe it's, a year and a half, year and 9 months, and that little calendar thing pops up and says, hey, you're about to run out of the statute of limitations before you can sue, based on that slip and fall at the rent house. And so now they got to go to work. They got to hurry up and file suit, except against who, right? I mean, if you're going to sue somebody, it's got to be an entity or something. Yeah. And, the general philosophy within the plaintiff's lawyers is sue everybody and then let them get dismissed, right? And so if they know there's a trust and they know there's a parent LLC, and, it's easy enough to figure out who owns the property, right? You can look at the deed records and say, okay, XYZ owns the property. So they know they've got to sue XYZ or XYZ Series 1. They know that. But they don't know who the management LLC of that is necessarily. They don't know the trust. They don't know all of that. And often they sue the easiest thing that they can determine. And then by the time they actually figure out who maybe some of these other parties are, the statute of limitations has run out. So there can be some very good reasons to use some anonymity in there, whether that's just not naming the LLC after yourself, right? The John Ross Investments LLC, right? Well, that's, we know who that one is. That's easy, and so they're going to sue John Ross, right? But even then, a lot of times people have a tendency to think that, okay, I live in, Arkansas, I live in Kansas, so I need to create a Kansas LLC for this. Well, that may be appropriate, but, I know like Texas, Arkansas, their secretaries of state disclose the ownership. You can go on the Texas Secretary of State's website, and for about $1 search charge, you can look at all the corporate filings on that. Take a state like Wyoming. Wyoming has specific laws that prohibit the Secretary of State from disclosing the ownership interests. So having, say, your Kansas LLC, but, the parent company be a Wyoming LLC, where even if they know the Kansas LLC exists, they're not going to be able to figure out that Wyoming. And even if they find the Wyoming, they're not going to know who the underlying owners of that Wyoming LLC are. It makes it much harder. And, if you think about these plaintiffs' attorneys as being just a little bit lazy, then, hey, make their job harder, and it might turn out in your favor because they miss a statute of limitations before they ever get a chance to sue you.
Right, exactly. Yeah, I think the other part about it is also that it has to, I would assume it has to do also with the perceived potential value of the suit, right? Like, I mean, it's obviously a difference if you have a $5 or $10 million suit, or if you have like a $100,000 medical bill suit or something like that. And the associated effort to chase all that down and actually prove that there was somehow something wrong by the owner, right? Like, so. Yeah, so I mean, in our case, I can just say that because I always say to my clients, mine is in Nevada and they have similar rules like Wyoming. They don't disclose anything either. And obviously, the series can all be in one place, and like in Wyoming, for example, they don't have to be spread around in different states. Okay, so now one thing that people also, when they start thinking about series LLC and stuff like that we discussed in our mentoring program, the question comes up, okay, so when I'm actually touching this topic, then it's not, we started with gifting. There's a kind of different kind of gifting in the kind of legacy transition, generational gifting, so to speak, which I think is also the same kind of limit, right? Like you can inherit quite a bit before you have to pay inheritance tax or stuff like that. But what I'm getting at is kind of like family trust versus the series LLC. Can you say a little bit how that works together, how that can be combined, how that would be best arranged?
Yeah. So when it comes to planning your estate, I personally am a big proponent of trust based planning as opposed to will based planning, which is going to require a court process after your death. It's going to be very public. Trust based planning is going to keep everything private. It's going to generally try to keep it out of the court system. Your LLC, you're using that for business management and asset protection. But now for your estate planning, you're trying to have a bigger box that you can put essentially the rest of your life in, not just your membership interests, maybe in these LLCs, but also your personal residence, for example, or your bank accounts, your checking accounts, it could be the beneficiary on your retirement accounts as long as it's properly structured. And I've always got to, point that one out. But there again, with the trust, saying the word trust is somewhat like saying the word surgery. There can be very simple ones and there can be very complex ones. And it depends often on where you fall in the strata of net worth. And weirdly enough, probably the biggest chunk of the people are going to be in what I would call the middle or relatively simple category. You mentioned the passing of assets and the death tax. The death tax amount is equal to that gift tax lifetime exclusion, the 12.06 million currently. Now that is set to expire in 2026, but even in 2026, it'll drop down to, my estimate's going to be around 7 million because there's inflation numbers in there. But still,
sorry for interrupting. I don't think it actually will, if you ask my opinion.
Right. And that's even assuming that it does, right?
Well, I mean, more and more people are going to become eligible to inherit. I mean, we are basically governed by like late 70s, mid 80s old people, right? And they have that same issue to tackle, and they want to be ultimately the one who half or almost half the amount of money that people can get without tax. I don't see it.
Absolutely. So you've on the very top end, you have people that have an estate tax problem. These folks with $15-20 million estates, right? Well, that's one category. And yes, they have very, very sophisticated planning needs. Then you've got the 90, probably 5% of the population. They're below the exemption amount, but they're not so low that they would struggle if they had, say, a long-term care situation. They've got enough money to cover their needs through retirement and to the end. But I will say that one category of people that often does fall through the cracks are this kind of lower 5 to 10%. And particularly when we talk about, real estate investors, I've had a lot of clients who have a relatively modest net worth, maybe 250,000 all total, maybe 300,000. But that's not cash net worth. That's their home and $50,000 to $80,000 rental properties. The income from that is enough to supplement their Social Security, and they get by. What those people don't realize is that if they need, if they have a stroke and they go to a nursing home that, private pay would cost, say, $6,000 a month, well, they don't have that kind of monthly income. And yet they're also not going to be able to qualify for government assistance programs like Medicare or in California, Medi-Cal, because of the value of that LLC or the value of those rental properties. And so for those folks, actually structuring a trust, not just to pass the assets at death, but also as a way to shield the value of those assets so that they do not count towards their eligibility for government benefit programs. Now, that can be a huge benefit for that category. In all of these cases, you're going to see trust planning. It's just going to be different for people that maybe could not afford their long-term care. It's going to be different for that middle group because they can cover the long-term care, but don't have so much to have to worry about the death tax. And then you'll have the trust-based planning for the people that do have to worry about the death tax. And so, yeah, but the recurring theme through all of that is generally going to be trust-based planning, just for the convenience, the ability to have all that set up, keep it out of the court system. Absolutely.
Yeah, thank you for explaining that. And I mean, one thing that I'm always pointing out for our clients, we are basically in business, for lack of a better way to describe it, to mentor people to get to a point that we call the time freedom point, where you have accumulated enough properties that cash flow so that you can supplement your normal day-to-day W-2 income with that cash flow, with that passive income. Now, obviously, to do this, and it's gotten much harder in the last 12 months due to the interest rate situation and stuff, but fundamentally, you always go for 20/80 or 25/75 kind of setup, which means you put $30,000 to $40,000 in and you get a $150,000 to $200,000 house. And you do this often enough over time, not obviously all in 1 year or so, but I always say in most cases it's about an 8 to 10 year time horizon to get to that point. But if you do that, you might say, okay, now I have 8 properties, and the total that, like your example was, I put in there is 250,000 over the last 8 or 9 years. But what people, I believe, forget, and why I'm also a big advocate of building the trust, is your tenants every month are paying down your mortgage. And it's not even so much that the kind of net value of the property increases because of that, but there will be a point in time where those mortgages are paid off or so low that you can just say, okay, my rent is now so high, my mortgage is so low, I make 2 or 3 more payments and then it's done. Well, now all these things that initially were $250,000 in asset value, if you want to, the rest is loans that don't really benefit you. Well, now if you have 8 or 9 properties and they're all 200,000, you have just on that, probably with some appreciation and stuff, a $2 million portfolio of properties, plus whatever is on the private side, right? And then it's not anywhere close to the limit, but it's still starting to be interesting where you want to say, okay, I don't want to drag this through the courts, and I also don't want to really have any issues if I get ill or stuff like that, because then you would never get out of, basically being constantly forced to liquidate your properties if you need any significant amount of money.
Yeah, you really, particularly when you've got ongoing events, you or really your family just they can't weather the delay in time after you die, right? Just because you're dead doesn't mean that the rent doesn't need to keep coming and keep getting paid. And if a water heater goes out, it still needs to get fixed for that tenant.
Right.
And so, yeah, using something like a trust where you have named successor trustees to step in and manage these assets. And then the very second that you're either incapacitated or deceased, bam, your person that you trusted is able to step in and take over, and they can collect those rent checks. They can access that bank account. They can pay for that water heater. And you're really not seeing any loss, from the tenant's perspective. Nothing has changed. They're still making their payments.
Yeah, I agree. And I mean, the other part that also doesn't change or maybe gets enhanced is the legacy perspective, right? That doesn't get eaten up to other things. But I mean, there is, besides having the income, there's also a little bit of a legacy component to it that can live on for generations if you do it right. So one thing with that, is people perceive this whole estate planning, land trust, series LLC somewhat as a complicated thing. And often I'm being asked, and now I have the perfect guest here to ask that to you, is what happens if I want to sell a property?
Sure. Well, if everything is set up correctly, you're going to sell it just like you would sell it in any other context. Now, the seller may be different, right? Instead of you personally being the seller, it's you as the manager of your LLC who's signing the paperwork. But instead of signing it John Ross, it's John Ross, manager of the XYZ LLC, or something to that effect, or John Ross, trustee of this land trust. But it's one way or the other. It's still you selling the property. And once it's done, for the most part, most of your LLCs out there, you're going to see taxed as either what we call a disregarded entity, meaning that it's just treated as if it's still yours, or possibly taxed as a partnership, maybe if it's a husband and wife and they're not in a community property state. In either case, you're going to be able to, if you want to take that money out and go party like a rock star the next day, you could sell that property, take the money, do with it what you want. If that property was in a series, Well, you now have an open series. And if you wanted to buy another property, you could buy that property in, series one, right? You sold the house out of series one, you got some money, you want to buy another house, buy, title that one in series one.
Yeah.
You don't even necessarily have to create a new series for it.
Right, and that brings up a good question as well for a tax expert. If I have that structure like you just described it, I'm still able to 1031 exchange, right?
Yes. So yeah, you can still do your
I don't want to
1031.
party like a wreck rockstar.
Yep. If you're doing 1031s, you can keep doing the 1031s. The LLC works just whether that's a series or a traditional LLC. You can still do your 1031s as long as you structure it and follow all the 1031 rules.
Yeah, obviously. Yeah, right. So if I hear you right, the only real difference is any leftover money or profits from the sale now go to my LLC bank account instead of my private checking account.
That's correct. They would go to your LLC bank account. But once again, if you wanted to withdraw that money from your LLC bank account and move it to your own personal checking account, that's just a distribution back to you. You're not going to pay any additional tax in excess of the capital gain on the sale of the property, right? You're going to pay that one way or the other. But otherwise, withdraw the money if that's what you want to do, or leave it in there for later use, or because that's a asset protected vehicle, maybe you want to keep it in there because you've got other things going on in your life.
Well, that or as a reserve, right? Like, so that there's always some money. I mean, I always recommend to have reserves built out of rent income. But if somebody had a big expense and wants to refill basically that reserve bucket, that's one way too, depending on the amount of money. Yeah. So I think that's awesome. I think we covered all the things, but I want to give you an opportunity. Is there any other thing that we haven't touched on in this context of Series LLC and trust that you wanted to let the audience know?
I think the main thing is for the audience is they need to make sure that they're visiting with somebody when they're having these conversations with their professionals, that they are talking to people that are up to date on these rules. The Series LLC concept is so new. I know, just for example, in Texas, we're on already about the third iteration of the laws because they created the first batch of laws. Then those worked for a year or two, and people saw kind of some of the problems with it. And so the legislators went back in and they tweaked it a little further. Arkansas just recently did a legislative update that made their LLCs much less attractive. And so I've got several clients where I had created Arkansas series LLCs that were now moving out of Arkansas, and we're re-domiciling them in places like Nevada and Wyoming. So you want to make sure you're getting advice from people that know what they're talking about. That's probably my biggest thing.
I think that's absolutely very good that you mentioned this. The other thing that I should probably mention real quick, and I hope you would agree, is if somebody has a Series LLC in a place other than where they are, like mine are in Nevada, so you typically need a registered agent to represent you in that state in some way. But I found that there are now so many agencies that do that for like 40, $50 a year. So it's really almost negligible. And unless you have something weird going on, I don't think my registered agent has ever in 5 years done anything else other than letting me know that the annual fee for the state is due or something.
Right. That's hopefully that's all they ever have to do, right? But yeah, you can use these other states. You just have to have a point of contact within that state. That's the registered agent. And yeah, there, like you said, there are any number of companies that will do that for very cheap. There are also many law firms that will do that. Often for a little bit more expensive, but there's lots of options for finding a registered agent somewhere locally in that state that you're seeking.
Yeah, exactly. Yeah, and that actually helps a little bit too, because then the address of the registered agent ends up in the official documents typically. So it's one more layer of the lawyer that you hired to dig through.
Exactly.
Yeah. All right. So one last question that I asked that has nothing to do with Series LLC or law or CPAs or stuff like that is, if you had a time machine, you could go anywhere, you could know what you know. You're not allowed to change the space-time continuum, but other than that, you can go anywhere. Where would you go and why?
I'm about a fourth generation Scottish American. And about a year ago, I went and spent about 3 weeks in Scotland learning all the history. I'm fascinated with it. I would really enjoy going back and just seeing the Clan Ross in the 1200s, with the tartans and the to me, I just think that would be fascinating to visit and see those castles when they were in use and the land and how it would be at that time. That just, to me, that would be fascinating.
Yeah, that's cool. And you could call yourself like John Braveheart Ross or something like that.
There you go.
By the way, did you get yourself the title?
I did. Yeah. In fact, while I was in Scotland, I got fully suited out, kilt, the jacket, the socks, the whole thing.
Okay. Are you aware that you can also officially get a title?
Oh no, a title? No, I did. I did not get me a title.
So you can call yourself Sir John Ross?
Well, I may have to do that.
Yeah, there's actually an organization in Scotland. There's an ecological thing. You probably know this. There is a rule in Scotland that's going back probably to the 1200s or stuff like that, where somebody who has legal rights to, like, I don't know if it's called monarchy or a title, but if you own a land that used to have a castle on it and you had the queen or the king had awarded you a title, then you can subdivide your belongings and you can award subtitles, not your own, but subtitles. Like Sir is, I think, the lowest, or Sir and Lady is the lowest you can get. And so this company sells 1 square foot parcels, which give you a certificate that say you are now Sir, whatever your name is. And for every parcel that I think it's $50, they basically plant trees for the money that you pay. But then you get it. Got that my wife for Christmas last year, made her a lady.
I like
because
it.
that was cute, and it's a really nice little certificate. So
That sounds like a great Christmas present. I'm going to tell my wife specifically not to listen to this episode.
yeah, exactly. Yeah, my wife was pretty surprised, especially because it came in the box and everything. Yeah. So. All right, cool. Well, John, thank you for being on the show. I'm going to ask one last thing, and that is, how can people who now say, well, I think I need a trust, or I think I need a Series LLC, how can they get in touch with you?
Professionally, they can reach out to my law firm. It's the Ross and Schollmeyer Law Firm. And although we are located in Texas, we practice really around the United States. I have clients from coast to coast. And so if anybody has any questions, they can feel free to reach out via our website, and happy to talk to just about anybody on these subjects. And if nothing else, I can point them to somebody in their area that I can at least maybe do a little background check on and make sure they're talking to somebody that knows what they're talking about.
Yeah, that's very good. And we will put your website and other contact information in the show notes. So if somebody wants to look it up, they can find it there as well. All right. Well, thank you, John, for being on the show. And thanks for all the great advice that you gave our audience.
Thanks. Pleasure.
Thanks for listening, and I hope you enjoyed today's episode of the Ideal Investor Show. More info and the links we mentioned during the show are in the show notes, or you can go to our website at idealwealthgrower.com and sign up for the Apple Podcast link. And if you like to talk to me, sign up for a strategy call. Hopefully you want to share what you learned with your network and bring more people in. We are really eager to hear your comments. And until next time, be well, stay safe, and ciao.